Blake Lively is doing everything in her power to, as she puts it, keep documents falling into the wrong hands.
And another problem cited by the court is that while Lively argues the subpoenas will show who was a part of the alleged smear campaign against her, the problem is the alleged negative campaign didn't start until August of 2024. So why would Blake Lively need communications in 2022 and 2023?
A Hollywood power couple is bound to have some secrets, but Blake Lively and Ryan Reynolds seem to be even worse than expected. For now, they're trying to prove Justin Baldoni wrong, but he's the one who's revealing them, and there's a court battle going on right now. What are the new secrets that are being told? Let's talk about how things have been going. Blake Lively's lawsuit against Justin Baldoni is also long, over 221 pages, which shows how many proofs he had. Of course, Blake's lawsuit is also long, but for someone who was accused of sexual harassment, Team Justin was able to come up with a lot of counter-arguments. Let's move on to the latest issue, which is whether or not to make text messages public.
Blake Lively is doing everything in her power to, as she puts it, keep documents falling into the wrong hands. She says there are 100 million reasons why Baldoni's side might try to leak text messages and other information. That's how much PR value that they have, she told a court yesterday at a hearing.
A lot of people say that the most recent hearing wasn't really about the lawsuit between Team Blake and Team Justin. Instead, it was about all the other famous people involved in the It Ends With Us drama, with Taylor Swift being the main focus.
But underneath that surface story, in a lot of ways, this hearing was really about Taylor Swift and some of Blake Lively's co-stars like Jenny Slate or Isabella Ferrer. They are the ones who would be protected. That's not obvious on the surface. This is one of those legal issues where there's just a lot bubbling underneath the surface of what you see. And unless you know kind of the inside scoop of how the legal process works, you're going to miss that. You won't understand.
In essence, both sides are fighting over a protective order. If there is a lot of private information in a lawsuit or civil case, a standard protective order is often put in place. But Blake wants something more than that. She wants an attorney's eyes-only order.
Attorney's eyes only means only the attorneys get to see this, not even the parties. That would mean that if Blake Lively produced text messages she had with anyone, then and they were marked as attorney's eyes only, well, that means Justin Baldoni can't see them. That means also the other defendants, because I think there are 10 who are named as defendants by Blake Lively, and Justin Baldoni's PR agents are also included as defendants, and so some of them also, or all of them who are defendants, would not be able to see these documents. So it's not just about public access, and in fact, it's really not about public access. The judge's protective order already covered anything of a personal and intimate nature regarding any individual.
In spite of what she says, it's clear that this is just an attempt to protect what's left of her image and control the public even more.
The judge's protective order already covered anything of a personal and intimate nature regarding any individual. So that was already there. And remember when I mentioned about that protective order creep, I'll call it, where more and more stuff gets shoved under there. That's going to be used to keep a lot of things under seal that really shouldn't be and that aren't personal and intimate, at least in many cases. That's how it would end up working.
This is soon after a judge turned down Team Blake's demand to reveal all of Justin's text messages, calls, and emails over a period of over 2 years. His team had a lot to say about that, pointing out how arrogant her team seemed to be acting.
They wrote in their letter to the judge, "It is hard to overstate how broad, invasive, and atypical these subpoenas truly are. This is civil litigation, not a criminal prosecution, and the Lively parties are not the FBI. Yet the subpoenas seek not only the complete call and text history of each of the targets over a period of several years, no matter the sender, recipient, or subject matter, but also over the same period, real-time location information and data logs reflecting, among other things, web browsing history."
After a meeting between the parties involved, Blake Lively actually agreed to narrow down the scope of the subpoenas issued, but Justin's team still felt they were too much.
Will improperly reveal the phone numbers of anyone with whom they communicated, whether it was related to this case or not. So they countered that the subpoenas should only be limited to communications between the phone numbers and the phone numbers of parties in the case and witnesses that Lively intends to call at trial. And it seems the judge has agreed with Justin Baldoni and Wayfair & Co., writing in his order, quote, "The subpoenas of the Wayfair parties' phone records, even as modified after the meet and confer, are overly intrusive and disproportionate to the needs of the case. The subpoenas request call and text logs between certain of the Wayfair parties and any other phone number, in most cases from December 1st, 2022 to the present. This request implicates legit..."
The judge also pointed out that Blake hasn't actually given any sign on how all of the obtained information would be filtered.
Even though Lively has narrowed her request to exclude the content of calls or messages, the phone records themselves would still contain sensitive information regarding which doctors, psychologists, or even acquaintances the Wayfair party spoke to and when. And the judge found that Lively hasn't shown how she would actually separate those numbers that may be relevant to the case from those that wouldn't. And the judge doubled down that even if someone doesn't have a privacy interest, let's say under the Fourth Amendment, protection against unreasonable searches and seizures, parties still have a privacy interest in their phone records under state or federal law. And Baldoni, Wayfair, they have a privacy interest in their communication.
And the final nail in the coffin was that they themselves claimed that the smear campaign didn't start until much later. So why would they want logs from so far back?
And another problem cited by the court is that while Lively argues the subpoenas will show who was a part of the alleged smear campaign against her, the problem is the alleged negative campaign didn't start until August of 2024. So why would Blake Lively need communications in 2022 and 2023? And then the judge writes, quote, "Lively has not provided a basis to believe that the broad discovery she seeks will reveal information regarding unknown participants in the negative media campaign proportionate to the burden on the Wayfair party's private..."
Coming back to Blake's latest demands, their lawyer had some not-so-nice things to say about Team Justin.
The parties in this case, on both sides, include people whose entire living is made off providing information to the press and content creators. There are 100 million reasons for the parties to leak information because the PR value is greater than complying with the court orders. In other words, there's a bigger advantage to winning in the court of public opinion than maybe even winning in the court of law. That seems to be a fair interpretation.
Blake's lawyer also said that their text messages could reveal trade secrets within the industry. One point that made sense was that she pointed out that Team Justin had subpoenaed the couple's security agency, and there was no need to do so that
this case involves what could basically be considered trade secrets. There are marketing plans, there are business strategies, there are client lists from public relations agencies, which could give competitors in the PR industry an unfair advantage if that information is disclosed. And she even expressed concerns about the potential leak of, quote, "specific security measures Miss Lively and Mr. Reynolds have taken to protect themselves and their families from this retaliatory campaign," because we know that this story has certainly...
Brian Fredman. Justin's lawyer took offense to how the other side had worded their worries. He also claimed that what Blake Lively's team actually wanted was simply a different law for them and their celebrity friends.
That anyone would suggest we would disregard a protective order. This is a case where no one has any intention of beating up or harming Miss Lively in any way. And Friedman went on to say that he believed the court's model protective order, which is the standard order that the federal court has, basically a template, that's protective enough. And as far as the attorney's eyes only stipulation or designation goes, Friedman argued that his team shouldn't be burdened with having to work around that, saying we shouldn't be put into a position where we're the ones that have to run to court every single time just given attorney's eyes only protection. My client has a right to defend himself. And he also argued that Lively and Reynolds' request would unfairly treat celebrities and powerful industry figures differently from everyone else involved in the case, saying it feels like what the other side is asking for is because there is a celebrity, because there are powerful people in the industry, somehow they get treated differently. Somehow there's a different law that applies to them that otherwise wouldn't apply to normal everyday people.
Of course, both parties have so far claimed that the other has been leaking information to damage their reputations and get the people on their side.
My clients have a right to defend themselves. That is in no way abusing the victim. Judge Lyman said that he is very aware of how all of this is playing out in the media. And Judge Lyman pointed out that both sides have alleged that the other has leaked confidential information that are difficult to trace.
The judge on the case said that justice is transparent, meaning they are most likely in favor of keeping a certain level of information about the case public, especially given the amount of attention it has garnered.
Lively and Reynolds were seeking to have the law bend to their desires, not necessarily the needs of justice. And justice is transparent, the judge said. Judge Lyman did not immediately rule today. He told both sides, "I'll give you my views soon," but
the judge has also stated that there is a certain amount of transparency they are expected to maintain.
Has garnered significant public interest. And he says, quote, "There is a presumption of public access in federal courthouses." The judge revealed, "Much of this information will become public as the case goes forward. For example, in motions for summary judgment, and of course at trial. There is a public interest in how the courts are being used that the court has to respect."
Meanwhile, the latest trial also addressed Justin's case against the Power Coup's publicist Leslie Sloan. She has previously not only asked for her to be taken out of the lawsuit, but also that Justin pay her legal fees. Of course, Team Justice has refused and reiterated that they have evidence against her.
Sloan parties and their co-conspirators, the Wayfarer parties, have been damaged beyond measure. The Sloan parties complain that they are unable to distinguish the allegations against them from those brought against other parties, arguing that the Wayfarer parties engaged in impermissible group pleading. Of course, it is premature at this stage to require the Wayfarer parties to specify the precise acts taken by the Sloan parties in connection with their conspiratorial scheme. A jury will determine the truth based on the evidence. Pause. This worries me. They already included evidence against Leslie Sloan in their first amended complaint. Why not remind us now about that? They have receipts. But maybe they don't want to lay it all out there yet. They claim, quote, "The Wayfarer parties have done more than enough to make their allegations against the Sloan parties clear and can easily amend their pleading to add further details based on what they have already learned."
And many have pointed out that her claims are pretty weak, given what she implied about Justin Baldoni.
That the Sloan parties made defamatory statements of and concerning each of the Wayfarer parties, individually and or as members of a small and readily identifiable group. Those statements are not inactionable opinion because they are falsifiable to the extent they contain, blah, blah, blah. Okay, remember, Leslie Sloan argued that she was just sharing her opinion that he sexually harassed her. That's not an opinion. That's a declarative statement. The Sloan party's false claims of sexual assault are sufficiently specific to constitute defamation.
Where people are also starting to suspect that Tamar Blake is using their influence to block videos that make them look bad. J.Y. Flair, someone who once interviewed Blake, talked about it on Popcorn Planet.
Extra diligent and careful.
I think so too. And I don't know if you spoke to Donna, the other creator that I speak to a lot too. She put out Instagram reels that were just started muted in the middle of the audio just went off. So there's these little weird things happening, and I've gotten a lot of comments lately from people saying that, "Oh, your videos don't show up in my feed anymore. They don't get recommended anymore." So I don't know if that's a coincidence or if it's Nick Shapiro.
It's weird. It's weird because obviously I'm not my first rodeo, guys. We did this with Adeptron. I remember this happening with Amber. There was a lot of tricks that they were doing.
Apparently, similar methods were used during the highly publicized Depp versus Heard trial years earlier.
And are you feeling she's doing it to us?
Definitely. I felt it was really uncomfortable feeling, I have to say, when I noticed the things about my Wikipedia page, because they were small tweaks, so I wouldn't necessarily have noticed, oh, everything has changed. There were little tweaks of wordings and, things, articles that were referred to. The first article in the references was a People article. that was kind of insinuating that I was the rude one in that interview, that I was inappropriate asking her, or not asking, congratulating her. And, so there were all these little things that made me look like I was a problem. And I think, I definitely think there's stuff going on.
JY said that part of the reason she is being brought up is that they cannot explain away something that happened years before. The "it ends with us" drama.
Yep.
They can blame that on Justin Baldoni or on Sony, whoever they're saying were responsible for, her tone-deaf PR campaign, because those interviews she did during the campaign that put a very negative light, that was obviously the smear campaign doing that. But with my interview, it stands alone, and they'll do anything in their power to try and find a connection with me and Baldoni's team, because then they're like, oh, we got her. She's on their team. And it was all a smear campaign.
Yep.
And so I do see what they're trying to do here.
The others have also talked about how the introduction of Nick Shapiro, who is ex-year into the case, means that things are getting even messier. And there are other channels who have noticed things going wrong with their videos.
I saw it personally myself. I mean, I literally already saw it, and I'm speaking to Billy Bush next week about this. Like, it's truly a conversation that needs to be had. I noticed a few things happening to my account last week on Instagram that have never happened in all my years, speaking out like loudly about all kinds of things. I mean, I'm an outspoken person. I speak about anti-Semitism. I speak about world news. I speak about all kinds of things, and never before have I been in Instagram jail until I spoke about Blake Lively. I mean, what in the world is happening here? And so that happened. I had a reel that my voice went literally silent the second I said her name. Why?
Dave Neal has also talked about how Instagram might be easier to push around for this sort of thing, given what went down during the Amber versus Johnny trial.
Versus Amber Heard coverage was happening. You could not say Amber or Johnny Depp. You could not say their names without it being immediately demonetized, and then upon review it would be approved. But they did the same thing with COVID, right? They say, you know what, these topics are so hotbed, we're going to demonetize them, which, while you still have your freedom of speech, you're taking away the incentive to make content by taking away the money attached.
Dave also talked about how certain journalists are now trying to shame content makers to back off by implying that YouTubers covering the issue are only in it for the money.
Financially shamed for talking about this?
Probably. I mean, I can't imagine why not. I didn't give them a number, but they were dying, drooling to know how much money I was being paid.
Yeah, so they asked you that.
Oh, like, it was weird. It was like, let me find every possible way to find out how much money you were being paid. And I'm like, we're still doing this? I thought this was like something you don't ask people, how much money you're getting paid.
They talked about how most of the artists covering the issue have been around a long time, and we're probably going to be covering it whether it took off or not.
Them about Bachelor, about other content. Zach has been around. All of these channels, we've all been around doing things way before Blake Lively and Justin Baldoni started making headlines. This is very important for the audience and the story and people reading Business Insider and Taylor Lorenz and all of these people to know. We didn't say, oh my gosh, jumping on this idea of doing YouTube content because this is gonna make us some bucks. We literally happened to cover a story that took off. I was going to cover this regardless if it was a big story or not, weren't you?
Oh yeah, I mean, I was already covering it, and then it kind of hit this fever pitch where it was like, all right, it's getting juicy, and the audience showed up for it, so they're invested. Yeah, it's so insulting to think that somebody who worked, and by the way, Business Insider, some of these organizations, it's like, you get out of there. Like, there's no way you're making good money doing that.
They're charging for people to read one article. Like, they're just as bad as us, if not 10 times worse.
Drop your thoughts in the comments below, and don't forget to like and subscribe for more updates on this crazy saga. We'll keep you posted as more information comes to light. Until next time.